The first round of the chapters that were launched in 2012, very much our approach from the technical panel then was that we identified topics that we thought made the core of what an OHS professional should know, and then we sought out Australians that we considered were experts or specialists in that topic and asked them to write on those chapters. As we have then moved into the second round of the body of knowledge, and probably these chapters are somewhat more challenging than the first round of chapters, we've taken a slightly different approach. For each chapter there was a topic-specific technical panel that included topic specialists, included a Safe Work Australia representative, included a representative of the Accreditation Board as managing the body of knowledge, and each technical panel also included an OHS professional to make sure that the experts stayed grounded. So that was very much a different approach. Also, with some of the chapters, we undertook research. While every chapter has an element of a literature review, some of them had much more extensive literature reviews. Many of the chapters had workshops, and also, particularly the organisational culture one, had a number of interviews. So there was real research that underpinned this. And then the writing was done by expert authors. In some cases that was drawn, or in all cases that was drawn from the technical panels. The other aspect that has been a little bit different to our first round was in nearly all of the cases we were able to do some what I'll call testing and validation by having workshops with some OHS professionals. So these chapters have had quite a different approach to the first round. So what we're going to do now is to move into a panel session so that you can get just a little flavour of what the chapters are about. So for the panel sessions, I'm going to ask the key authors or representatives of the authors to come up and sit in chairs along here. And for each chapter, we have an OHS professional who has had a look at the chapter, is going to give some comments on what they see are the implications for practice, and excuse me, and put some questions to the author. So if I can ask Robin and Carmel and Neil, and we have David Verus in the ether. So if I can ask the authors to come down, and also the OHS professionals that have been allocated, Yim and Spo and Mike and John. And I will introduce each of them as we get to the chapters. The first chapter that we're going to have a flavour of is the Principles of OHS Law. And before you all leap down the authors' throats about why it's OHS law and not WHS, it was very much a strategic decision, and WHS has been used for reference to specific legislation, and OHS has been used to talk about law generally. So before you all get tied up in that little idiosyncrasy. So Neil is going to speak on behalf of the authors, but I would also like to acknowledge Barry Sheriff, who was in the room and made a major contribution to the chapter, as did Eric Windholtz from Monash Uni. Richard Johnson was also a contributor to the chapter, and Leo kept them on track as well. After Neil has made his introduction to the chapter, Chim is going to give her thoughts about the chapter and engage with Neil. So thank you, Neil. Do you want the bottom one goes forward?
Thank you, Pam. It was a real privilege to be involved in putting together this material, and it does demonstrate that lawyers can occasionally agree on something when you get them to come together. It was definitely an exercise which was done as a collaborative thing. We had a number of we didn't actually meet face-to-face in person, but we had video conferencing to put all these things together. And so, yes, and I've been designated as the notional lead author, but it was definitely a collaboration between all of us, and all the people involved made a great contribution. And Leo, in particular, was very helpful in keeping us on track and helping us to see where we were going. I guess law as a topic is an important one in this area. It's I say to the students when I'm teaching workplace health and safety law that it's a tool. It's not the only tool. You don't change workplace culture simply by enacting laws, but it is one of the tools that we have in our society for changing behaviour. And it's both a tool for actually changing behaviour because of the threat of punishment, but also in many ways it actually says symbolically some things about what we care about when we enact laws in these areas. And so for this reason we think it's an important area to contribute. So if you get a hold of the new chapter, basically this is a bit of a rundown of what we do. We go through the basic principles of the legal system. Now we go through a background to where historically the OHS law, WHS law system has come from. People really need to understand a little bit of the background in the factories legislation, in the previous OHS legislation and the way that it's developed. The material then goes into some of the core concepts of the legal system. And in particular, one of the things we want to try and do is to give people an idea that this law stuff doesn't just drop down from the sky. It is developed, what the sources of law are in Australia, both the legislation and the common law, and how those two things work together. Legislation from parliaments, regulations, common law developed by judges, and one of the big things, as I'll mention in a moment, is the intersection between those and how the law means what judges say it means, and so some ideas about how judges actually interpret the law. So those are key concepts behind the idea of where the laws come from. And then in particular we're looking at the WHS legislation. We focus particularly on the Uniform WHS Act and some of the common terms that are used in there. The idea of work, and Barry gave us some very interesting material on what it is for what work is, what a PCBU is, what it means to be an officer, what it means to be a worker. We then looked at the liability issues, and I guess a big focus of our discussion is when will people be liable under legislation. We looked at the structure of the general duty of care, who has it, in what circumstances is it imposed. We look at the reasonable practicability and some of the other qualifiers that apply to the duty of care. So those are the sorts of issues that we're looking at. Of course, it's a slim volume. We can't cover everything in the legislation, so we've tried to illustrate the sort of way that people should approach it through some particular examples and go into some of the issues that are particularly going to interest people. We talk about governance and the duties of officers, due diligence and what that means when an officer is in charge of an organisation. We also then go through the enforcement procedures, the sorts of general sanctions that are available and the sorts of tools that are used in that area. If I can just mention two key issues that I think this makes an important contribution, and there are others as well. But this idea that I mentioned a moment ago that legislation and what legislation means is not just a matter of understanding the English language and how the sentence fits together, but knowing that the courts are interpreting these against a background of previous legislation, against a background of other courts having interpreted these things. And so we comment a little bit about what principles do courts apply when interpreting legislation. We talk about the fact that, for example, you can take into account previous committees and of inquiry and all those sorts of things. We talk about the other principles. Briefly, we discuss some of those principles about how courts interpret legislation. The other thing we do is we give a practical example in the middle of the paper about how a court undertakes a grammatical analysis of a provision. So you're presented with section 19 of the uniform legislation, which talks about the duty to take care in reasonably practicable ways. How does a court analyse that? An example of the sort of grammatical analysis that is undertaken, and hopefully that illustrates the sort of approach that people can apply in other areas. Now, just a couple of caveats. I'm a lawyer, I've got to give you lots of caveats. One of them is that doing this chapter won't make you a lawyer. Sorry if you thought that. But the idea is that we hope that having OHS professionals who aren't lawyers, who read through the chapter, will have a better understanding of how the law is shaped and framed, how the legislation is set up, and in particular know areas where they need to go off and talk to a real lawyer and highlight areas where that's important. And the other thing is to say, and I'm afraid I couldn't miss the opportunity to say, that a number of those of us who are authors have written other books that deal with these issues. There's one by myself, there's Richard Johnston and Elizabeth Bluffnell and Clayton, Barry Sheriff and Michael Toomer. Now that's just a mere sample of some of the books, but these are further resources that you can go and have a look at. So that'll do me, I think, for the moment.
Thank you, Neil. If you'd like to stay there, and we'll invite you, Chim, to come up.
Sorry, I don't have any publications to advertise here and market. Well, firstly, I'd just like to commend both the authors and also the technical panel for actually developing and writing an excellent document. As I was actually reading through it, I was reflecting back on my time as a student and going through my 2 hours of law once a week for a whole semester. I do recall falling asleep quite often in that session. But but certainly reading through the document, and I was trying to put my feet in the shoes of an undergraduate. It was extremely informative and it was educational. It was certainly put in very simple terms and simple language. And the examples that were provided that Neil had discussed very briefly were ones that were very easily understood. Certainly, as I was actually coming to the end of reviewing the chapter, there were probably a couple of key components which I sat there and thought, well, if I'm either mentoring a student or if I'm actually an undergraduate and obviously having provided, worked with a number of organisations providing health and safety advice, what's actually missing? So there were certain parts like Part 3 of the Act which talks about instant notification and Part 5 of the Act which talks about consultation participation. There's certainly things or areas in which the regulator strongly focuses on when they sit there and they speak to organisations, say, well, tell me, how have you demonstrated a good level of consultation participation with your workers? So the first question that I do have for Neil is around, I guess, what were the decision-making process or thought process that the technical panel went through in deciding what were the right sorts of topics, and I do acknowledge that you can't cover everything, but what were the thought-making processes around deciding what were the key topics to include in the Principles of Law chapter, given that consultation and participation is such a significant part of what organisations and officers and organisations need to be able to demonstrate.
Well, thanks, Ian. And it is true that there's stuff that's not here, and we all wrestled with the very strict limits that were placed on us in terms of the number of words we could use and all those sorts of things. I suppose a theme of the chapter is when someone comes to deal with the principles of OHS law, I guess we are hoping to convey issues about the liability. Under what circumstances can someone be found responsible, criminally responsible in these areas, and the big central issues of liability under legislation, and also to talk about enforcement and how those things happen. And of course, consultation and notification are really important ones. Actually, Ian gave me a slight heads up on this one, and I must say I did go back and find out that footnote 5 on page 15 does mention the fact that duty holders are to consult, cooperate and coordinate. So it is there.
Very briefly.
Very briefly. But the other thing I think we felt was that there were various other practically oriented components of the body of knowledge which will give people much more information about those ongoing obligations of consultation and other things like that. So yes, it receives a brief mention, but I guess we were focusing particularly on some general ideas about legal interpretation, liability principles and enforcement issues, which are the main things that we cover.
Mm-hmm. Great. And
we could have lots of long discussions, but I think that has given us a little bit of a feeling for the Principles of OHS Law chapter. And thank you. I did catch Yin on the hop last week, and so I thank her for her time in reviewing the chapter and her preparation.